I'll do a brief introduction of Steve Schwinn, who's our speaker this evening. I know many of you have had an opportunity to enjoy previous presentations from Steve, whether they were at the last SCOTUS recap that we had, or at an issues briefing, or many other things that you have done for League in the past. You know then that Steve is a professor, constitutional law, correct? Constitutional law professor at UIC. He has done some publishing, works in civics with some younger folks as well, from what I've read from your profile, and is a true friend of the league. Really helps us out in understanding a lot of what's going on the legal side, and particularly now at a time when our Supreme Court seems to be making some decisions we might not have otherwise expected a few years back. And so we're really, really pleased to have you here with us this evening. And maybe you can shed a bit of light on those decisions for us. In the meantime, I do want to direct you to the Q&A for your questions this evening rather than chat. If you've got some technical difficulties, you can go ahead and throw those in the chat for me, and I'll kind of monitor that a bit as we go this evening. Otherwise, please send them into the Q&A, and I'll interject where I can and see if we can get Steve to address those. About a dozen or so of you did submit questions in advance, and I did send them over. So I think that as the presentation evolves, you'll see some of your questions be answered as part of that, because he did have a little bit of a preview of those beforehand as well. So without further ado, Steve, I will go ahead and hand it off to you.
Awesome. Excellent. Thanks so much, Kathy. I just want to do a quick sound check and video check. Make sure everybody has me. Are we good?
You're loud and clear, and I think we can see you just fine.
Excellent. Excellent. Well, thank you very much. If you have any problems, please let me know. We have just shy of 90 minutes, I think. Am I right on the timing? Which gives us, oh, I don't know, maybe a hundredth of the time that we need to cover all of the issues going on today. Oh my goodness, what a whirlwind, right? Well, listen, Kathy, thank you so much for that very kind introduction. League members, I'm just delighted to join you once again to talk about the Supreme Court and what's going on in the current political climate. It really is an honor and thrill to be with you. Many of you I've met before. For those of you that don't know me, again, Steve Schwinn. I teach at University of Illinois Chicago School of Law. I teach constitutional law, comparative constitutional law, human rights, civil rights, First Amendment, and similar type issues. I follow the Supreme Court closely and what's going on in the Trump administration. I focus especially on the separation of powers and how the separation of powers affects individual rights. And we can talk a little bit about that tonight because there's so much interesting things going on these days. And just on that point, I do want to say, you know, I think we all have a sense of this. My students don't always because they come to the law fresh, but we've been around long enough to know that these really are extraordinary times. And so I want to talk a little bit about that with reference to some of the questions that you all submitted to Kathy before the event tonight and see if I can touch on many of those. If I don't touch on your question, I hope you'll drop it in the questions, the Q&A for Kathy, and she can interject and ask me. If you have other questions along the way or other comments, please go ahead and drop them and let us know, and we'll be happy to address them as we go. Depending on kind of the pace and rhythm of things tonight, we can see if there's time for Q&A at the end, or if we just want to do it kind of as we go along. And try to make this as conversational as we can with the Zoom format that we have and so many of you participating tonight, which again I truly appreciate. It's really a pleasure to be with you. So let me start, if I could, by just riffing on that last point that I mentioned, that we really are living in extraordinary times. And what we're seeing is constitutional law and the very structure of our government changing in seismic ways right before our very eyes. This is one of the reasons that I love American constitutional law so much is that it changes literally every year and really every day. My colleagues who teach classes like torts or contracts or property in law school, they can teach from notes that are 35, 40, in some cases 50 years old. But for me, I've got to change up my teaching notes every year, every 6 months in some cases, every quarter. It's a constantly evolving doctrine, which is very exciting. What it means is that political players and civil society players like you and me, we are making constitutional law every single day. It's not just the president, the Supreme Court, the House Speaker, the Senate Majority Leader. It's not just your state legislature, your governor, or your local city council. It's you and me and things that we do and talk about every single day. This is a constantly evolving doctrine. It's constantly taking shape. You and I are constantly forming our government. And I urge you and challenge you to go out there and engage in civil discourse, just like we are tonight, and then turn around and take action around it because we're living in very exciting times. What I tell my students is the Trump administration and the Supreme Court and Republicans in Congress, I don't want to get too partisan about this, but I'd be saying the exact same thing if they were Democrats. These actors are making dramatic constitutional change right before our very eyes. As I said, seismic constitutional change, tectonic constitutional change. Huge changes are happening. What I tell my students is look, our Constitution allows for that. It allows for that in the ways that we're seeing right before our eyes, whether we agree with the policy changes or we disagree with them. And what's exciting about that is that if political actors like President Trump or the Supreme Court or those in the House and the Senate, if they can make this kind of constitutional change, well, you know what? You and I can too. And so I hope that's an empowering message for you all. The way that we do that is through ordinary civil discourse every day, exactly like the conversation we're going to have tonight. And take this conversation back and talk to your family about it, talk to your friends, talk to your community, and start to instigate for change. As we go through the talk tonight, we can also talk about other ways that you can get involved and make change in our constitutional system. I think the times call out for it. And again, I urge you to get involved in your communities and in the way our Constitution is taking shape. I urge you to take action, and I urge you to go out and exercise your rights. So there are a couple of things that we're seeing these days that I want to touch on that overlap with many of the questions that you all ask in advance of the session tonight. And I think what I want to do is just as a longtime observer of politics and policy and constitutional law, separation of powers, and similar kinds of issues, I want to give you my own modest take on what I think is going on in these really extraordinary times and the strategy that the Trump administration and its allies seem to be using to make constitutional change, again, right before our very eyes. I think what's happening here is that the Trump administration is implementing policy in a way that is extra constitutional. And by that, I really mean unconstitutional. What I mean is, it's taking action that our Constitution plainly does not allow, our history and tradition simply don't support, and we haven't seen other presidents or other political actors take this kind of dramatic action for a long, long time, if ever, in our country's history. I'll give you just an example ripped from the headlines this week. President Trump and the Secretary of Education are moving to dismantle the US Department of Education. Well, as it turns out, the president can't do that. President Reagan also wanted to dismantle the Department of Education, but he couldn't get the votes in Congress. That's what you need to do. If the president wants to dismantle the Department of Education, the president needs to go back to Congress, the body that created the Department of Education, funded it, and vested it with statutory authority that the president is charged with enforcing, not destroying. So when President Trump starts to dismantle the US Department of Education, that really is an extra constitutional, and again, what I mean is unconstitutional action on the part of the president. Now, the moment that we find ourselves in, the politics don't align so that Congress will push back on that. Ordinarily, we would expect that Congress would say, hey, that's our prerogative. We're the ones who create, vest with authority, and fund the US Department of Education. And the president, I don't care what their party or politics are, the president shouldn't be doing that unilaterally. But in these political times, we can't count on Congress to do that. And so we might look to the courts. The courts, after all, we know going back to the 1803, the founding of our country, where the Supreme Court said that the courts are the body in our separation of powers system that can say when the president is engaging in illegal behavior and put a stop to it. Well, in the current political times, we're seeing the Supreme Court also not step up to the plate. And so what we're seeing is constitutional change being made by a president that's acting unconstitutionally in a way that is not checked by the coordinate branches of government. That's where our system is designed. The framers designed our system so that each branch would push and pull against each other. They expected each branch to try to exercise outsized power within its own portfolio, but that the other branches would push back and keep each branch in check. And through this dynamic push and pull, we would see different policies implemented, different constitutional change made, and new versions of the separation of powers. But today in 2025, two branches of government seem to have fallen asleep at the switch. And what seems to be going on is that they have enabled and empowered a president to go ahead and make these extra constitutional changes and literally shape our separation of powers system in ways that we just have not seen before in our country's history. Or if we've seen them before, it's been few and far instances between. Now, the problem with this is that when we reshape our separation of powers system and when we empower the president, what happens is we do it for some period of time. It's not like we do this for 4 years, and if we end up voting Trump out of office or a Trump supporter out of office, that things will go back to the way that they were. It just doesn't work that way. The president, in exercising this outsized authority, is establishing a kind of precedent for future presidential action. And what I tell my students to try to be nonpartisan about this is look, President Trump is taking some actions. You may like them or dislike them, but don't make a judgment about presidential authority based on whether you like the president's actions or you dislike them. Make your judgments about presidential authority about how that authority would be handled in the hands of somebody that you disagree with. If you like Trump and you like this outsized presidential authority, ask yourself the question, would you like it in the hands of a President Biden or a President Obama or a President Harris? Maybe not so much, right? And if that's your answer, maybe what you ought to do is rein in your thoughts about outsized presidential authority. So we can check our separation of powers commitments, including presidential authority, against that kind of non political intuition. Do these things work when parties are in power that we disagree with? So, one of the questions was, are we in a constitutional crisis? I'm going to opine briefly on that and then continue this story about what I think is going on in the Trump administration. You know, maybe a week or two ago, I was still pretty, I'll say, skeptical about whether we were in what we might call a constitutional crisis. And let me explain. First off, there's not a settled definition of what is a constitutional crisis. We probably know that, for example, the Civil War was a constitutional crisis, or our country's very founding was a constitutional crisis. But within the bounds of ordinary politics, it's hard to know exactly at what point do we kind of cross over from ordinary or even extreme politics into a constitutional crisis. And there's not a settled definition for that kind of thing. But I'm going to offer some thoughts on that and explain to you why my thinking on this has evolved over the last couple of weeks. We've seen President Trump again take some really extraordinary extra constitutional actions where Congress has not pushed back. And we now have enough data points at the US Supreme Court that the Supreme Court is unwilling to push back, or at least to allow President Trump to take these actions while cases are pending against him to stop them. But the net effect of that is that the actions will be taken. And so we're seeing a Supreme Court that seems to be enabling and empowering this president's extra constitutional actions. In my view, that's a constitutional crisis. It's not an irreparable one, but it is a constitutional crisis. What it means is, again, we need to take action and be empowered ourselves in civil society and go out there and have conversations like what we're having tonight, have them with our friends, our family, our community, and try to influence people and try to get them to think about things differently. And then engage in political action as well, voting, using your voice, contacting your representatives, getting involved with litigation to the extent that you can, and getting involved with administrative rulemaking, which gets a little bit into the weeds, but is a really important and actually empowering way that we can get involved in our politics. And so a number of other questions touched on kind of related issues about things like the Supreme Court's ethics, for example, or the role of nine unelected justices in our system. And should we really be allowing nine unelected justices to make these kinds of consequential decisions in our system, or whether we can change the composition of the court or impeach justices and things like that. And so I'll say just a few beats on that, and then we can get into some of the trends that we're seeing at the Supreme Court in the Trump administration and even outside of it. So let's start with Supreme Court ethics. It turns out that the Supreme Court does have an internal code of ethics of its own. The problem is not that it doesn't have a code of ethics. The problem is that there's no enforcement mechanism outside of the court itself. The court has taken the position that as the high court in the land, it cannot be bound by a code of ethics except for by itself. And what that means as a practical matter is that the code of ethics is enforced by individual justices on the court against themselves. There's no outside enforcement mechanism. So, for example, if a justice sees a conflict of interest in a case that's coming down the pike, they can decide themselves unilaterally whether they want to recuse or not. There's no rule that they have to recuse, and there's no enforcement mechanism that would force them to recuse. That's not true in the lower courts. In the lower courts, there are codes of judicial ethics that are enforceable in various different ways. But again, the Supreme Court has taken the position that because it's the high court in the land, it can't be strictly bound by a code of ethics. Now, there's a lot of work going on around this. There are a lot of instigators in civil society trying to get the Supreme Court to take a code of ethics seriously, and that work will continue. It's important work. But currently, we don't have a code of ethics that's enforceable at the Supreme Court. Now, what about something like what Congress could do to enforce a code of ethics or to enforce against justices that seem to be maybe behaving in ways that Congress doesn't like? Well, justices can be impeached, just like the president can be impeached in our system. A justice can be impeached. It hasn't happened very often in our country's history, just a handful of times, but Congress can initiate impeachment proceedings against a sitting justice. I don't see that happening in our current politics, and even if it were to happen, I don't see it coming through to full fruition. In other words, I could imagine the House of Representatives might impeach, but the Senate wouldn't convict or something like that. But there does seem to be a kind of bipartisan reluctance to take that extraordinary action against sitting justices today, even though politicians on both sides freely criticize justices that they disagree with. So, what about things like changing the size of the Supreme Court or maybe adjusting its funding or its jurisdiction or something like that? Well, it turns out Congress has a vast amount of power and authority over the Supreme Court. Congress could change the number of justices that sit on the court and pack the court or strip it. Congress could reduce the court's funding or reduce its jurisdiction so that it could only take certain cases and not others, or maybe not take any cases at all for a particular term. again, over the course of our country's history, we have seen Congress play with those devices from time to time in order to influence the way the court is impacting American politics and constitutional law. I don't really see that happening today. Again, there's a kind of bipartisan consensus that the Supreme Court should do its job and try to interpret and enforce law faithfully to the best of its ability, and even when we disagree with it, as parties on both sides have vociferously over the last few years, even when we disagree with it, that we ought to respect the opinions and kind of march forward in our politics. There were some other questions that came in that touched on related issues. And again, if I'm missing somebody's question, I hope you'll remind me. And Kathy, you can chime in at any point. Please feel free to interrupt me. I get tired of listening to myself talk, um, and we can talk about your questions.
Well, I do have one item that I'm going to ask you to opine on, and if you don't want to, that's fine too. Um, the makeup of the Supreme Court shifts around, obviously, with the different appointments over the years. Do you view what's happening on the Supreme Court today as seeing the court become politicized, or do you see it as two vastly different sort of philosophical camps on the meaning of the Constitution or
Yes,
interpretation of the Constitution, or both?
or both. Yes. Let's talk about the political court for a minute. Um, This court is hotly political. It divides 6-3 on many of the most important and hot button issues, with a 6 justice politically conservative majority and a 3 justice politically progressive minority. We'll talk about some of those cases tonight and what we're seeing on this particular court in these particular political times is even sharper differences between some in the majority and some in the minority by conventional political standards and understandings. In particular, we're seeing Justice Ketanji Brown Jackson come out with some very, very strong dissents, criticizing the court's majority as basically enabling a move toward authoritarianism in our government. She hasn't used that word, but that's the gist of her argument. And some of the justices in the majority, most notably Justice Amy Coney Barrett, firing back and saying, Justice Jackson doesn't have any constitutional basis for making these claims, and she doesn't have any ground for saying what she's saying. And so we're starting to see the knives sharpen a little bit in some of these hotly controversial cases. That said, I'm going to remind everybody that so much of the court's work is done with unanimous decisions, 9-1 or 8-1, 9-2 decisions, and in many cases we see surprising alignments among the justices. Now, what I will say about that, because that's the sort of standard line that I'm supposed to tell you as a law professor and as a court watcher, it's the important cases and the controversial cases where we're seeing the sharp political divisions. And so I do think it's quite accurate to say that this is a very, very hotly political Supreme Court. I also take a historical view. We've had a hotly political Supreme Court at other constitutional moments in our country's history. And so this moment, while it is unusual for a variety of different reasons, the court being a political institution in our political system is not necessarily new and different. We have, again, seen instances of a very political court. And I'm just going to remind, I'd mentioned 1803. That's the year that Marbury versus Madison came down, a case that many of you or all of you might know. This was the case that established federal judicial review of actions of the executive to rule those actions legal or illegal. And if you want to read about hot politics, read about the political situation around the turn of the century from the 18th to 19th century and Marbury versus Madison. These were very hot politics at the time. So this is something that really goes all the way back to our founding, and we've again seen other instances of a hotly political court throughout our country's history. Um, the other part of the question, whether remind me, Kathy, so the first part was about politics. The
Yeah,
other part,
did you see it as more of a politicized, a politicization issue, or is it just that there are two very different philosophical views of
thank you.
how the
Yes.
Constitution should be
And
interpreted?
an important point. And I love the way the questioner framed the question. Uh, it is an ideological debate on the Supreme Court. It's ideological on two levels. There are political ideologies at the court, undoubtedly, just like you and I have political commitments, the justices do. And just like you and I might have a hard time checking them when we put our robes on, the justices undoubtedly do as well. The other debate is a doctrinal debate, a theoretical debate about how to interpret the Constitution, how to interpret federal law, what our separation of powers system ought to look like, what our federal system ought to look like, and what the power of government ought to be in a democracy. And there are good faith arguments on both sides about how to interpret the Constitution in a kind of static, hidebound, originalist way versus in a dynamic, flowing, evolving, living constitutional kind of way. That's a fundamental debate that we see on the court. But we also see debates about how to interpret statutory language, how to interpret constitutional language, to what extent do we rely upon things like legislative intent in interpreting statutory language. And we see debates about things that aren't written in the Constitution or law, or at least not explicitly. Like how much power should the president have in relationship to Congress, right? The Constitution gives us some clues, but it doesn't give a determinate dividing line between the powers of the presidency and the power of Congress. And so there are good faith debates about whether the president ought to have relatively more power or the Congress ought to have relatively more power and how we balance those out. And then, of course, the judiciary itself is exercising power by deciding these questions. And so we can't leave the courts out. And so, yeah, this is a deep, deep ideological debate as well, a theoretical debate about all those things that we talked about. And so, yeah, my answer is yes, it's both political and ideological. Ideological, absolutely.
There are a couple of questions in the Q&A. I think they're probably quick answers, Steve. The first is not understanding Barrett's reprimand of Brown Jackson. And are these sort of, is this is this legitimate stuff, or is this personality conflicts between the justices, or what do we got going on?
Well, I don't have any inside information, but I don't believe. I'll tell you, it's hard for me to believe that Justice Jackson and Justice Barrett are not personally civil to each other, if not outright friendly with each other. We've had very strange bedfellows on the court from time to time that are ideologically polar opposites. Here, I'm thinking about Justice Scalia and Justice Ginsburg when they were both on the court. Very, very good friends, even though you couldn't be ideologically different. Justice Scalia and Justice Breyer went on a kind of roadshow to talk about some of these ideological differences that they had in interpreting statutes in the Constitution, and in doing so, they kind of demonstrated their friendship and their collegiality. And so, again, I don't have any inside information, but I don't think that this is personal. I
Sometimes
think
they just
the
have to agree to
justices.
disagree.
I think that's exactly right. Yeah.
Okay.
Yeah.
The second, there are two questions here, and they kind of are similarly themed. Um, the Senate obviously is approving nominees to the court, right? And the question is whether a Mitch McConnell not allowing Obama to nominate, and then doing what he did during the first Trump administration, and then can it's Okay, very, very much the same thing. Can such a thing be avoided within sort of the constitutional law, or is this simply prerogative of the Congress?
Uh, the Constitution doesn't provide determinate answers to these kinds of questions. And I'll tell you how some in my world would look at a Senate Majority Leader McConnell holding up President Obama's nomination of Merrick Garland to the Supreme Court. What they would say about that is you can't really say it's unconstitutional, but it's constitutional hardball. That this is hardball politics within the boundaries of the Constitution. The Constitution doesn't prohibit it, but it is pretty extreme politics. What that might say is a political actor is well advised to avoid those kinds of politics, right? And to avoid them, because once you take those measures, you set a precedent that your opponent can do it in the future. And so McConnell, I hope on some level, when he held up Merrick Garland's nomination, I hope on some level he was thinking, at some point there will be a Republican in the White House and a Democratic leader in the Senate who is in a position to hold up a Supreme Court nominee of a Republican under similar circumstances. And I'm actually setting the precedent for that. Um, if he thought about that, he quickly, sort of put it out of his mind and went ahead anyway. But I do hope that he gave some thought to that.
Okay.
Um, so much of what we're seeing in today's politics could be constitutional hardball, but I think, the reason for me anyway that I do think that we're in a constitutional crisis is that we've now moved beyond hardball to just playing extra constitutionally.
I assume you're going to talk a little bit about immigration and due process and whatnot. I've got a question here, but I'm going to let you go ahead and move forward. And my guess is that you're probably going to address that as you go. If not, I'll follow up on it.
Well, it's a really nice transition, Kathy. And if I can use that as a transition to talk about the court's so-called shadow docket and some of the rulings that we've seen recently on the shadow docket. And I want to preface this by saying that we have just come out of an important, maybe even very important Supreme Court term. But even an important or very important Supreme Court term is far overshadowed by what's been going on the court's shadow docket, which is a docket that it's not a formal docket that the court sets. Um, it's a docket that is an emergency docket for the court. Let me explain. Sometimes the Supreme Court will get a petition by a party in a lower court case to do or not do something on an emergency basis. I'll give you the most common example for the Supreme Court. If there's a prisoner on death row, they can petition the Supreme Court as a last court of appeal to stop their execution pending some further measure of process, due process, or court proceeding, making an argument that something about the process was wrong or unconstitutional, or something about the execution is wrong or unconstitutional. And so the Supreme Court gets these kinds of emergency applications on its so-called shadow docket pretty regularly. And it usually disposes of them very, very quickly, usually unanimously, and almost always without explanation. That's the court's shadow docket. Now, the reason that this has become controversial is because the court has started to use its shadow docket for other kinds of substantive decisions. I'd mentioned a few moments ago the Trump administration's dismantling of the U.S. Department of Education. I'll use that as an example because we got a shadow docket ruling in that case just this week, just on Monday. So the Trump administration decided that it would unilaterally dismantle the U.S. Department of Education, fire about half the workforce overnight, and start to outsource some of the functions of the department and start to shut down entire offices within the department, even though those functions and offices and employees are in federal law and enjoy federal legal protections. even though Congress created the department, created these offices, created these functions, and invested them with authority and funded them, the Trump administration went ahead and shut them down unilaterally. Well, predictably, there was a lawsuit challenging that. So what happened in the lower courts is the lower courts issued what we call a preliminary injunction. What that means is that the Trump administration was prohibited from shutting down the Department of Education while the lawsuit proceeded on the merits. So this preliminary injunction isn't a ruling on the case. It just says, look, we're going to pause things, we're going to maintain the status quo while the case proceeds through the courts. So both lower courts, the federal district court and the federal court of appeals, upheld this temporary injunction against the Trump administration and enjoined it, prohibited it from dismantling the Department of Education. Well, the Trump administration went to the Supreme Court and asked for what we call a stay of the injunction, asked the Supreme Court to overturn the preliminary injunction on its shadow docket. The Trump administration filed a brief. It was literally a brief in the case, making jurisdictional arguments, what we sometimes call technical arguments in the case, and not even arguing that Trump had authority to shut down the Department of Education. That wasn't even part of the argument. The plaintiffs in the case responded, and the Supreme Court ruled. And on Monday, what the court did was to stay the lower court's injunction. In other words, lift the injunction and go ahead and allow the Trump administration to dismantle the Department of Education while the case is pending in the lower courts. Now, let me unpack that for you and just illustrate how dramatic that is. So, what the court said was the Trump administration can continue doing this, but the court didn't provide any reasoning or explanation for why the Trump administration could continue doing this. We might make an educated guess about what the court was ruling on. We might guess that the court was ruling on one of the jurisdictional or technical issues that the Trump administration raised, but we don't really know. For all we know, the court might have been ruling that the president does have authority unilaterally to shut down a federal agency. We just really have no idea because the court didn't provide any explanation. Justice Sotomayor did write a dissent, joined by Justice Kagan and Justice Jackson, that also may provide some clues to us. But again, that's a dissent. It doesn't explain the court's reasoning in the case. So the problem is we now have a ruling from the Supreme Court that allows a president to conduct activity that most people in my field, and by most I mean all people in my field, think is extra and unconstitutional, that a president simply doesn't have authority to do that. And yet they nevertheless are permitted to do it pending the outcome of litigation. Now, you might say, well, the underlying litigation still goes on. So ultimately, the courts might rule that dismantling the Department of Education is beyond the authority of Trump. Sure, ultimately they might. The problem is the dismantling will have occurred. And reconstructing the department, especially in today's politics, after the president has dismantled it, will be almost impossible. And so this is what I meant in the introduction when I talked about the court enabling and inviting and empowering the president to take these unconstitutional, extra constitutional actions that really are quite dramatic and effecting a seismic shift in our separation of powers. Now, that was one case that came down on the shadow docket, but there were several other cases that involved agency dismantling or terminating officers of independent agencies by the president that the Supreme Court similarly ruled on the shadow docket that the president was able to continue doing pending the outcome of lower court cases. In one of these cases, President Trump fired two members of independent multi-member boards in the federal government. President Trump fired a member of the National Labor Relations Board and a member of the Merit Systems Protection Board. The Merit Systems Protection Board, the MSPB, is charged with protecting federal employee employment rights. So it's kind of ironic that the president would unilaterally terminate a member of the MSPB, but nevertheless, there you have it. Now, what was stunning about this is that the Supreme Court in 1935 ruled that these kinds of multi member independent agencies enjoyed protection from at will termination by the president. In other words, the Supreme Court ruled in 1935 that independent members of multi-member agencies cannot be summarily terminated by the president. They can't be. If Congress designs them that way, the president cannot fire these people. And yet the president went ahead and did it. They sued predictably. And again, the lower courts held it up. They said, we're going to issue a temporary injunction and require the president to reinstate these individuals pending the outcome of the underlying litigation. The Trump administration again took the case to the Supreme Court on the emergency docket, and the Supreme Court again lifted those temporary injunctions, allowed the president to terminate those officers pending the outcome of litigation. But again, the problem here is the court didn't explain its reasoning. And once the damage is done, it'll be very, very difficult to put those officers back into place in today's politics. Now, along the
I'm going
way,
to
I
interrupt
mentioned,
for just a second. Is this, are there actions similar to the stance that they took on the the s- the scope that a federal judge's decisions could be? So in other words, it could, I think what did they decide, that it could only be a handful of the actual people that were plaintiffs in the case and not everybody that might be affected by it or something. I can't remember exactly what the logistics were, but is this really kind of hamstringing the federal judges in a way that we haven't seen in the past, or is it something else?
yeah, it's a what a thoughtful and insightful question. It, in my view, what the Supreme Court seems to be doing is consolidating judicial control at the Supreme Court and not empowering and deferring to lower court judges who really are closest to the cases in these cases. And I think that's been intentional on the part of the Supreme Court. Um, it's on net, I would say, disempowering for lower federal court judges. Now, a lot of folks would say that's good. That's good because in today's politics, we see that parties go around judge shopping and file their cases in courts where they think they'll find a friendly judge, for example. And parties on both sides of the aisle have complained about what we call universal or nationwide injunctions. And I want to talk to you about that in the context of the birthright citizenship case that came down earlier this spring. Um, that lower court judges can issue these universal or had been able to issue these universal or nationwide injunctions, halting the president's action across the country, even though those lower court judges had jurisdiction only over the case in front of them. And so that's been a hotly controversial practice again, on both sides of the aisle. And I can walk you through that analysis when we talk about birthright citizenship. But Kathy, I think you're exactly right. I think what's happening here is the Supreme Court is consolidating judicial control at the Supreme Court level and really disempowering and taking away the power of lower court judges who really are, they're the ones who are on the ground. They're the ones who are hearing the evidence, examining the record very closely, listening to the parties about the actual cases that are being decided. And so that consolidation is somewhat alarming to me as well. In the in the NLRB case and the MSPB case, the Supreme Court issued a shadow docket ruling staying the preliminary injunction on the part of the lower courts. And I had mentioned this 1935 case that said that the president could not unilaterally terminate members of multi-member agencies that are independent. The Supreme Court didn't even mention it. And so it looks like a ruling that effectively overturned that 1935 case, which is a pretty dramatic thing for our courts to do, without even mentioning it, much less explaining why it was doing it. And so we're seeing this kind of trend on the court's shadow docket in all of these cases that I think is, in my view, is really quite alarming and I think it's safe to say for Justice Jackson and for me, I think is sending out alarm bells about a loss of our democracy. We had a question came up earlier about immigration. A number of immigration cases have come up on the court's shadow docket. And the court's record here on net has been, again, very favorable to the president. There have been some court rulings on the court's shadow docket where the Supreme Court has said that individuals are entitled to some measure of due process before they're sent to before they're deported or sent to a third country. But more recently, the Supreme Court has effectively allowed the administration to deport individuals to third countries. And I saw in the papers today that the administration is now doing that, has resumed that action, and is now starting to deport more people to third countries and kind of ramp up that effort. And so we'll see what happens with that. But again, this was all empowered by the Supreme Court on its shadow docket. I'm going to pause there just for a second, Kathy, and see if you or anybody else has questions. I do have one question in chat that I want to circle back to, but then maybe we could talk a little bit about birthright citizenship and some trends that we're seeing on the courts on that side of things. Oh, Kathy, I think you're muted.
There's one in the chat, and then there are a couple in the, but since you're looking at the chat, feel the court is not just mirroring prior political ideology differences from the past. When you have Leonard Leo specifically influencing the court with his vast wealth, that's a different situation. So
Yeah.
this kind of goes back to your original ethics question as well. Yeah.
Yeah, we're seeing outsized influence by Leonard Leo, although he's kind of faded now, but outsized influence by individuals who who have a lot of resources and can influence politics through their resources, having an outsized influence on the Supreme Court, and that too is quite alarming. Um, the court itself has opened the door for that kind of influence.
And what about, there's a question about Justice Roberts in terms of his sort of being in control or managing the court versus being dominated by other justices.
What a great question. And this is something that a lot of court watchers talk about. Can we call this the Roberts Court, suggesting that Chief Justice Roberts has some measure of control over what's going on, or should we not call it the Roberts Court? And where does Chief Justice Roberts fall on the ideological spectrum of the court, and what role does he play in the court? I think those are complicated questions. Let me tell you what many in my field say, and then I'm going to tell you why I think that's not quite right. What many folks have said is that Chief Justice Roberts is an institutionalist. And what they mean by that is that he is out to preserve the institutional integrity of the Supreme Court. And that's a principal motivating factor for him in decisions that he makes and the way that he writes, cases that he votes to hear, and other actions that he takes as Chief Justice. Um, there's some evidence for that he is an institutionalist. For example, he's been outspoken publicly when President Trump says that there are Biden justices or Trump justices. Chief Justice Roberts came out quite vocally and notably and said, "No, there aren't. We're just justices." He's also come out publicly and criticized criticism of judges because it's led to violence and threats of violence against our judges in the federal and state court systems. And so and there have been some things that he's done in different opinions here and there that also suggest that his principal motivation really is the institutional integrity of the court. And that might be, at least in part. What I worry about, and why I think that that doesn't tell the full story, is that he has also taken a lead in dismantling the Voting Rights Act. Here I'm thinking about the Shelby County case that effectively wrote Section 5 preclearance out of the Voting Rights Act. He's taken a lead in race discrimination cases and saying that the government can't use race for any reason, even to try to level the playing field in situations of institutional inequalities. And and he's taken other positions here and there that that I think are maybe don't align with the story of him as an institutionalist. I'm thinking about his dissent in the marriage equality case, for example, um, that was a very sharp dissent and maybe somewhat sharper than it needed to be. And so I think there's some truth to him being motivated by institutional integrity, but I'm not sure that that tells the whole story.
Okay.
And whether he's controlling the court or not, I think that's hard to say what goes on behind the scenes at the Supreme Court. But if you look at the head count on the court and the ideological alignments and who's voting with whom, who's in the majority most of the time, who's in the dissent most of the time, and things like that, I'm not sure that he looks significantly different than any other justice on the court. And so it's not clear to me, at least based on traditional indicators, that he has an extra outsized influence on the court, although as chief, he undoubtedly has some extra influence on the court.
Interesting. I'll let you take 2 seconds to answer this one. How do you stay so calm talking about all this unconstitutional craziness?
Well, that's a good question. Thank you very much. I will take the caller out for a beer and we can talk about it. And I'll show that I can be a little less calm about some of these things. No, I think it's important to I th- I think it's important to dial down the rhetoric in today's politics. I think passion is important, but I think we ought to talk to each other respectfully. I feel very strongly about that, and and try to work through differences and educate each other and come to common understandings or misunderstandings. And so that's really my motivation.
With the hope that leveler heads will ultimately prevail, I assume. So,
Yeah, and maybe not. I don't know, but we're, we're all just doing our best, right?
so
Oh, I lost you again,
I
Kathy.
accidentally hit my mute button. What else? You wanted to talk a little bit about birthright citizenship. I don't know what else was on your list of things to chat about this evening.
Yeah, a couple of other things that I think we ought to talk about. Birthright citizenship is a really big one. This is another illustration of how the Trump administration has used kind of technicalities to sidestep judicial review and effect a policy that everybody agrees is flatly unconstitutional, except those in the Trump administration who are promoting it. And I got to tell you, on some level, I got to think that they think it's unconstitutional too. This is birthright citizenship. So we know that the 14th Amendment, enacted in 1868, protects birthright citizenship. It provides for citizenship of the United States for anybody born in the United States and subject to the jurisdiction thereof. That's the language of the 14th Amendment. What the Trump administration has picked up on is that phrase, subject to the jurisdiction thereof. And it's made an argument that if your parents are not citizens of the United States, they're not subject to the jurisdiction of the United States, and therefore their child isn't either. And so their workaround for birthright citizenship is that children born in the United States to parents who are not U.S. citizens aren't subject to the jurisdiction thereof under the 14th Amendment and therefore don't qualify for birthright citizenship. Now, that's an extraordinary position to take for a lot of different reasons. First off, every president, every Congress, every scholar going back for a long, long time has not interpreted the 14th Amendment that way. Instead, the way that most or all of us interpret the 14th Amendment is that if you're born in the United States, you're a U.S. citizen. The second reason that it's extraordinary is the Supreme Court rejected that argument over 100 years ago in a case called Wong Kim Ark. In 1898, this was a Chinese person, a Chinese national born in the United States to non citizen parents. His parents were Chinese and traveled back to China to visit relatives. When he tried to re enter the United States, he was denied re entry on the ground that he wasn't a citizen. He appealed the case up to the Supreme Court, and the Supreme Court said, yeah, he was born in the United States. He's a citizen. It doesn't matter that his parents were not citizens of the United States. What matters is that he was born in the United States. And so the Trump administration defies not only most or all of our history and common understanding, but also a centuries old, more than centuries old Supreme Court case that says exactly the opposite of what the Trump administration says. So a number of states and pregnant persons brought a case against the Trump administration, arguing that this was an unconstitutional interpretation of birthright citizenship, and they sought a preliminary injunction halting the president from enforcing the president's view of birthright citizenship. And they won. They won in three different cases and in appellate courts. Every single lower court judge to look at this question said that the Trump administration's position was unconstitutional. Some judges, including Republican appointed judges, went so far as saying that the position was the most unconstitutional thing that they'd seen on the bench. The language here was really quite extraordinary. The Trump administration, oh, and then those lower court justices or judges issued these universal or nationwide injunctions, halting the president from enforcing that view of the 14th Amendment nationwide across the country. Now, what's important about that is that these judges had particular parties in front of them, some states, some individuals, but nevertheless, determinate particular parties in front of them. And yet they nevertheless granted relief nationwide to everybody. Well, these so-called nationwide or universal injunctions have long been controversial, as I mentioned earlier, by both sides. Republicans used them against President Biden. Democrats have used them against Trump. And there's widespread agreement that universal injunctions can be used by a political opponent to stop a president from enacting policies that are favorable to the president's supporters. And so the Trump administration took this to the Supreme Court and asked the court the question, do the lower courts have authority to issue these universal or nationwide injunctions? Now, importantly, the Trump administration didn't ask the Supreme Court to say anything about birthright citizenship. The case had nothing to do with birthright citizenship. It had to do only with universal or nationwide injunctions and the lower court's authority to issue them. Well, the Supreme Court ruled that lower courts do not have authority to issue nationwide injunctions. They only have authority to issue relief to the parties before them. Now, I'll say a little bit more about that in a second, but the effect of the ruling then was to empower the Trump administration to enforce its view of 14th Amendment birthright citizenship against every individual who has not sued the Trump administration. What it means is that the Trump administration can continue to enforce its view of birthright citizenship unless and until it's sued by every single person who might be subject to its view of birthright citizenship in the United States. And the Trump administration will surely move to do that. At the same time, the Supreme Court said there's a possibility that when the states are plaintiffs in a case like this, or if individual pregnant people can form a class action, and bring the case as a class action, or if a plaintiff can challenge the president's action or lower federal officials' actions implementing the president's directive under what we call the Administrative Procedure Act. If that kind of case can be brought, then maybe a court can issue a universal or nationwide injunction. But that's not the way these cases were brought. And so these cases are now back in the lower courts. The ACLU, representing a group of plaintiffs a week or so ago, you kind of lose track of time with this fire hose of activity. But a week or so ago, the ACLU filed one of these cases as a class action. The judge moved very quickly on the case and issued a universal nationwide injunction for the class, and that seems to comport with the Supreme Court's ruling. But the case will inevitably go back to the Supreme Court, and at some point, the Supreme Court will have to answer the question about whether the president's view of birthright citizenship comports with the 14th Amendment or not. So stay tuned for that. We'll see that either next term or the following. But this is just yet another illustration about how the Trump administration has effectively used a kind of, again, I'll say technicality. That's not quite right because it's a really important maneuver, but a kind of technical maneuver to dodge judicial review of its behavior and nevertheless go on and engage what most or all think is flatly unconstitutional action.
Will most of these cases, though, not ultimately get to the Supreme Court, or are you simply saying that, yeah, they might get there, but they might be moved by the time they get there?
Mostly the latter, but the birthright citizenship case presents an unusual situation. Let me explain. I'd mentioned earlier that all the courts that have examined the Trump administration's view of birthright citizenship have rejected that view. When a when a party loses, it can appeal, but it doesn't have to appeal. And so, one tactic that many of us think the Trump administration might use here is to lose these individual cases, but decline to appeal them to the Supreme Court so that the Supreme Court never gets a chance to rule on Trump's view of birthright citizenship. Now, if there's a judge out there or an appellate court out there that would rule in favor of Trump's view of birthright citizenship, then the plaintiffs in the case could take the appeal to the Supreme Court. But remember, Trump's view of birthright citizenship is so widely regarded as unconstitutional, it's going to be hard to find a panel of judges that are going to say that it's legal. And so the nature of the case means that the Trump administration itself is going to have control over whether the court case gets to the Supreme Court or not. The court, by it on its own, just won't reach out and take the case. A party has to appeal to it.
I do have a couple of questions here before I get too far behind, but related to the birthright citizenship case, I don't have a good feel for how state boundaries play into sort of your citizenship.
Yep,
So if
yep.
if Illinois, for example, was a party to the case, and so it's okay, we're clear. If if you have birthright citizen here in Illinois, it's all good, right? But I probably don't want to take a vacation to Florida anytime soon. So how does that, how does that work in terms of states' boundaries? Because I know that was just a decision on something to do with that was just made as well, I think, for Florida. Um, but how does that work when you're in a country and your citizenship is the country versus, all these individual states now that may have a different.
Versus the states, right? And a patchwork of citizenship would be bananas in any country, whether it's a federal system or not. And that was one of the principal arguments in favor of a universal injunction in these cases, because without that device, we effectively have this kind of patchwork of citizenship in this country. But here's where I'm going to get into the weeds here just a little bit. Here's where the states as plaintiffs, the states themselves as plaintiffs, may be able to leverage a universal injunction. The way this would work, let's go back to Illinois. Now, it turns out Illinois was a party to one of these cases. And so if that case prevails, as it likely will, then a person born in Illinois is a citizen of the United States by birthright citizenship under the court's order. Okay. But that won't be true in Indiana, who was not a party to any of these cases. And so if our person then were to travel to Indiana, all of a sudden they would lose their birthright citizenship. But here's where the state's participation in these cases becomes so important. Let's suppose instead that there's a child born in Indiana who does not enjoy birthright citizenship because of the Trump's view and because of the fact that Indiana was not a party to any of these cases. Now that person seeks to move to Illinois, right? And Illinois officials at that point have to make a decision. Is this person a US citizen or not? Because they're going to claim benefits under Illinois law that attach by
That gets
US
really tricky.
citizenship, right? And so Illinois officials are going to be pulling their hair out trying to figure out who's a citizen, who's not a citizen under this patchwork system. Now, because of that, the states, in my view, have a really good claim for a universal or nationwide injunction because they're going to have to deal with this headache of patchwork citizenship if it were otherwise, right? And so Illinois, when Illinois goes into court, what they can say is, look, we're going to be substantially harmed by trying to sort out who's a citizen or not a citizen from people coming from Indiana or Kentucky or Iowa or any of these states that are not a party to these lawsuits. And therefore, we really need a nationwide injunction to give us, the state of Illinois, complete relief in the case. We'll see whether the Supreme Court buys that argument. I think that's a pretty strong argument for a universal injunction, though.
Well, and I can see where the passage of the big, not so beautiful bill, imposing citizenship requirements for various benefits now.
Yeah.
This really gets kind of sticky if every state has a different rule for how they're determining that. So it's going to be really interesting to see how that plays out.
Absolutely. And a lot of federal benefits already tied to citizenship.
Mhm.
Welfare benefits, SNAP benefits for food stamps and the like are tied to federal citizenship. And when states administer those programs, which they do, they need to make an assessment about whether a person is a citizen or not.
Well, I'm going to ask a couple of additional questions here. They're a little bit more general. If Congress doesn't hold the president accountable and SCOTUS is using shadow docket to enable the president's unconstitutional actions, where are the pressure points for change kind of back in the other direction?
Yeah, good question. So, continued lawsuits, I think, are an important potential check against the president. Now, if the president can sidestep those lawsuits by appealing to the Supreme Court on the shadow docket, that does undermine that as a kind of pushback. But nevertheless, we are seeing really an unprecedented number of lawsuits against the Trump administration in the first few months of this second administration because of the very aggressive actions that it's been taking. So that's one way. Um, we'll see what happens in the midterms, right? A lot of people are predicting that there will be a blue wave in the House. I'm not sure the numbers align for the Senate. There's an interesting move in Texas, if you've read the papers in recent days, to redistrict mid-census, which is
Thank
highly
you.
unusual, in order to try to help Republicans retain a majority in the House of Representatives. Gavin Newsom in California has already announced that if Texas does that, he'll do the same thing in California. And so we may see a wave of mid-census redistricting in order to figure out how to get a majority in the House of Representatives. That Texas case, by the way, implicates a voting rights issue under Section 2 of the Voting Rights Act that that a number of folks
Assuming
have
anyone cares about the
had their
Voting
eye
Rights
on.
Act at this
Yeah,
point, but
well, it's with racial gerrymandering versus political gerrymandering and how that happens under Section 2 of the Voting Rights Act is it turns out to be a really important issue that may come up in that Texas litigation as well. Um, And so that the midterms, just our voice, of course. We have First Amendment free speech rights and associational rights to join clubs like the League of Women Voters, where we can amplify our voices by achieving economies of scale. We can contact our local representatives, our national representatives, our federal representatives, and exert pressure in that way. Um, and I had mentioned earlier, everything that the Trump administration is doing as a formal matter, most things that the Trump administration is doing as a formal matter are going to be reported on the White House website as an executive order or in a publication called the Federal Register as an administrative action. It turns out, I had mentioned the Administrative Procedure Act a few minutes ago. It turns out that this APA, the Administrative Procedure Act, requires federal government agencies to go through a rulemaking process before they issue new regulations. And so, if the Environmental Protection Agency is stepping back on enforcement of the Clean Air Act or Clean Water Act, you may be able to see some of that in the Federal Register. Now, what's exciting about that is part of this rulemaking process allows you and me as individuals, or the League of Women Voters, or your community organization, to write in with comments. And it requires federal agencies to consider those comments. Now, will the Trump administration do that? I have no idea. But that's an empowering way for us to get involved in ordinary politics.
Appreciate that input. Thanks. Other question about ICE raids by the masked and unbadged uh, individuals, hopefully agents, and the constitutionality of that, the justification for their actions to be used against not just supposed undocumented immigrants, but also kind of by profiling individuals, right? By the way they look. Um, how, what is similar recourse? In other words, there's not much other recourse. I guess the question is really what other recourse do we have left? And it sounds like it comes kind of back to your last statements.
It's not a hopeful situation. So we have seen ramped up ICE enforcement of immigration laws, and we have seen ICE officers acting out without a uniform and even with masks on in making some arrests and detentions. And we've seen strategic action on the part of ICE moving detainees from site to site so that they can never get habeas corpus jurisdiction in a court, right? As soon as they would file a petition in a court, they would be moved to a different location, thus depriving the original court of jurisdiction, at least according to the administration's reckoning. And then by the time they actually get to court, they're probably on a bus or plane to be deported to a third country without a measure of process. And the administration has demonstrated that it's willing to take all of these actions and more in its robust immigration enforcement. Um, we've seen some pushback on this, and we've seen some hopeful signs in the lower federal courts granting injunctions against the Trump administration for taking some of these actions. But again, on the court's shadow docket, the Supreme Court, for reasons that we don't really fully know because the court hasn't explained them to us, has effectively allowed the Trump administration to continue to do most of this kind of robust enforcement of our immigration laws. The recourse for an individual immigrant is to file a claim in court. But it's very hard to do, right? Because they're being moved around, they're being moved quickly, they're being deprived access to attorneys, they're being forced to sign documents in languages that they don't understand, and being manipulated and abused in other ways that is really preventing them from obtaining judicial recourse. But but the advocates are working on it and doing their level best to try to catch up with the Trump administration's tactics.
I think you may have answered this, but is it political and or cynical for the Supreme Court to make so many decisions that do not address the core issues that are being litigated. So I think it's the shadow docket comment that you made.
Yeah. What a great question. So I'll tell you what I think the Supreme Court majority would say in these cases. It's exactly what Justice Amy Coney Barrett said in response to Justice Jackson's criticism of the majority opinions in these cases. What I think they would say is, look, for the Supreme Court to overreach in response to executive overreach raises the exact same constitutional problems that executive overreach raises in the first place. In other words, if the Supreme Court or lower federal courts are doing things that they're not really empowered to do, why is that any different or any better than the president doing things that the president isn't empowered to do in the first place? I think is what they would say. Now, I'll tell you my problem with that is that the whole purpose of the separation of powers is that the coordinate branches will push back, right? And sometimes that means pushing back with powers that maybe they haven't quite yet recognized. And so the Supreme Court, by taking a very modest position with regard to its own powers in these cases, is not only aggrandizing the power of the president, it's also diminishing the power of the courts. And again, when we see these kinds of seismic changes in our separation of powers, it's not like they're going to go away in the next presidential election or with the next appointment of the next Supreme Court justice. The institutional actors are setting precedent for a longer horizon and effectively empowering the president and minimizing the power of the courts for a period of time until we get political actors in those positions that are willing to reverse course on those trends.
Thanks. Couple of additional questions. I have one. I'm going to kind of some of these you're sort of alluding to or answering as you go there, but how do you feel about whether well, I'll just read it. Um, does Professor Schwinn recommend that we need and should have a constitutional convention to write a new constitution? Which scares the heck out of me. And if so, that said, even if you don't ask me questions, super informative. Okay. That I think that's the basic question there.
Okay, so first off, don't call me Professor Schwinn, please, Steve. Professor Schwinn is literally my dad. Second, as to the Constitutional Convention, look, I am all game for that if it's folks on this call. Um, but, but, but I'm also scared, Kathy, if we were to call that with a wider group. I'll tell you where my passion lies. I feel very strongly about civic education. I think that's really important. And civil dialogue around civic education, I think, is an important value in our society that we've really lost and really lost in understanding how to do it. Um, I have deep faith that with activism and civic education, that we can effect changes that we want to effect within our constitutional system without going to the extraordinary length of having a constitutional convention. Our Constitution is brief, it's short, it's vague. And what that means is it gives us a lot of room for ordinary politics in our system. And we've seen that swing. If you think about where we were in the Obama years versus where we are now, for example, just in that short period of time, the way our politics have swung, our Constitution allows for some or all of that. And again, that's really exciting to me, and I think ought to be empowering to us all. And I think again, I feel very deeply and passionately around the idea that if we can talk to each other, influence and educate each other through civil dialogue, we can effect the kind of constitutional change that we want to see.
I think many of us on the phone are in violent agreement with you. Our patience might be running a bit thin, but but
Uh-huh.
but yeah, I think so. Couple of questions. There are a few more here, but in the interest of time, I did have a couple of questions related to do you is there anything you think that's going to be popping up over the next several, weeks or months here that you think we should be keeping an eye out for?
Yeah, 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 I do. I do. So we didn't mention, but I will mention very quickly, the Supreme Court issued a couple of opinions this term that are not favorable and in fact outright unfavorable toward LGBTQ plus rights. I think that trend is going to continue into next year when we see a challenge to restrictions on LGBTQ participation in athletics, and I think this trend line is going to continue, and so I think that's one thing to keep an eye on. Another thing I think to keep an eye on, we had three cases this term on religious rights, and one of them overlapped with the LGBTQ rights that I mentioned. Three cases on religious rights at a time when the Supreme Court has been on a tear, I would say maybe a 10-year tear, to expand religious rights in our country under the religion clauses in a way that not only allows and not only even invites, but in some cases requires religion in public life in ways that a generation ago we never would have imagined. And so I think this is an important trend at the court. We're going to see more and more religious rights and religion playing a larger and larger part of our public life under the Supreme Court rulings. And then finally, one thing that I've got my eye closely on, I kind of alluded to this earlier, independent agencies within the federal government. When Congress designs an independent agency like the NLRB or the MSPB or the Merit Systems or the any of the alphabet soup of independent agencies in the federal government, Congress is designing those under congressional authority. But I think the court is on the cusp of saying that the president can dismantle them if the president wants to, which again would overturn a 90-year precedent going back to this 1935 case, Humphrey's Executor, um, and really upend our understanding of the separation of powers and presidential authority within that scheme. And so I've got my eye on that as well. Oh, and just one more thing, and I apologize. I just keep going on and on and on. Voting rights, voting rights, voting rights, voting rights. I cannot emphasize enough. I'd mentioned this, what's going on with the mid-census districting in Texas. There are other attacks on Section 2 of the Voting Rights Act. I think that's critically important to keep our eye on.
Very good. Let me go here and just ask a couple of, we just did that. Oh, question about holding, I'll just read it. When the reconciliation was done for the big beautiful bill, did it still include a section that would disallow courts from holding federal employees in contempt? So
Oh, good
there
question.
was a,
I don't remember if that ended up in the final version or not. I'd have to go back.
okay.
I'd have to go back and
I
look. No,
thought they had
I don't
taken
have
it out,
an
um,
answer.
but good question. All right, something for us to look into. Um, we talked a little bit about LGBTQ rights. Um, I have a question on Illinois Constitution. Is that something you can opine?
Maybe,
All right.
maybe.
What do you think about a constitutional amendment to change Article 5 of the Illinois Constitution? Oh, Article 5 to mirror the way we do amendments to the Illinois state constitution. So is there a way for us
Uh,
to adapt the US Constitution differently?
Maybe. The problem is that any amendment, even to the amendment process, would have to meet the super majorities in our current constitutional amendment
Which would
process.
be, okay,
And I'm not sure that enough of us can come together in today's politics to come to an agreement like that. Um, but certainly something to think about. My own view is that we as a society have kind of come to a place that we've accepted that we can make political change within the broader structure of our Constitution, and that we'll continue to kind of wrangle and wrestle over the meaning of the Constitution and seek constitutional change outside the amendment process through ordinary politics and advocacy in the courts. Um, I'm not sure that's the best answer for a constitutional democracy, but I think that's kind of where we've come to as a people in 2025.
I'm going to ask you one last question here this evening before we wrap up, and that is that based on what you're seeing, how do you feel about the likelihood that we will sort of evolve or devolve into something that looks a bit more authoritarian at the executive level than what we might have ever imagined?
Yeah. I think with each passing day and each Supreme Court decision that comes out on the shadow docket, that becomes likelier and likelier. And it's a terrifying thought to me. It literally keeps me up at night. Um, I've been teaching a seminar the last couple of years and doing some writing and work on democracy's moves toward authoritarianism. And when we look at what's going on in this country, we can check all the boxes, right? There's a kind of checklist for what authoritarians do from, from all the familiar countries where we've seen moves to authoritarianism. And, um, and we're doing all those things here in this country, just jot for jot, doing every single one of them. And so this is deeply concerning to me. And again, I think a call for us to all engage and try to make change.
Yeah, I think a lot of us have had that similar fear, so I appreciate the fact that none of us now, all 100 of us on the call now, are not going to sleep for a week. But also for
Sorry about that.
yeah, the time you've spent with us to walk us through this and make sure that we have a solid understanding of what actually is happening. And also to hopefully instill a sense that there are things we can still do, and that's what our mission is, and to encourage us to continue to do that. So very much appreciate it. I also understand that you are going to be helping out the Palatine League, I guess, by doing some
Yes.
speaking next week, maybe
Yes.
on the
Um,
22nd. So those of you that are on the call, if you have not had enough of Steve for the last hour and a half, that's likely a virtual event, but you can go out to the either the Palatine or the Illinois website and look for that event. And maybe you can get a cameo appearance here from Steve, who I think is going to be talking a little bit about executive power at that.
Absolutely. And I think we're actually going to be in person at the Schaumburg Library.
Oh,
So,
oh, you'll be
yeah,
in
I would
person. Okay,
invite
great, great.
anybody who is free and available. I'd love to see there. I also, Chris says hybrid. Um, I also dropped my email in chat. I don't know if everybody can see that or has access to it. It's
Let
Schwinn,
me.
just my last name at uic.edu. If you have any questions or comments, drop me a line. I'd love to hear from you.
I'll just go ahead and stick it in there and send it out again to everyone. There you go. You should all be
Awesome.
able to
Thank you.
see Steve's um, email at this point. Well, thank you so much again. I have a couple of other comments as well, saying how valuable this session was, is it always is to us, and appreciate your time this evening. I will be on vacation, so I won't see you next week, but hoping a few
Enjoy.
extra folks will show up, and you can address the executive power issue in a bit more detail for us. So thank you, and have a great evening. Thanks
Thank you,
everybody for attending.
everybody. True honor. Thank you.
Good night, everybody.